Good morning to all the viewers. Myself, Dr. Rajesh Singh, Associate Professor from Parul University, Parul Institute of Law. I warm welcome our two speakers. First of all, I will tell the topic of this webinar. The topic is the legal education now and challenges ahead. First of all, I would like to brief about Honorable Justice Dr. Satish Chandra sir, who is the former Justice from Allahabad High Court. About sir, he has enrolled as an advocate in the Bar Council in 1975, and he has done his LLM gold medalist, and he has also done LLD, that is a Chancellor medalist in the law. He has also specialization in the constitutional law, international law, and taxation law. After completing his education, he stabbed the practices as an advocate in Allahabad High Court. Later, he served as a law teacher in the Bareilly College, Dungar, PG College, Bikaner, and MD University, Rohtak, HP University, Shimla. He was also visiting professor in LBS, National Academy, Mussoorie, Internal Security Academy, Mount Abu, and various institutes in Russia and Poland. The Hague Academy of International Law, the Hague, has awarded a fellowship to Dr. Chandra, and he was a visiting professor in Institute of the State and the Law, Moscow. He was a constitutional advisor to the government of Zanzibar, as well as a judge and High Court of Zanzibar. He was a consultant honorary to the Constitutional Review Commission of Zambia too, and he was also appointed at the Sultanate of Oman as the first legal advisor. He also served as the Law Commission of India as a director, additional law officer since 1989 to 1997. He was also a judicial member in the Income Tax Appellate Tribunal for more than a decade, since 1997 to 2008. He is an author of 15 books and 35 research paper articles on the various aspects of the law. He elevated as an additional judge on 6/8/2008 and took oath as a permanent judge on 19/4/2010. So on this platform, virtual platform, I warm welcome you, sir. Now I will tell about senior advocate Pallav Sishodia, sir. Sir, he was born in Jaipur, Rajasthan, completed school education from Sardar Higher Secondary School, Jodhpur, Rajasthan. He has done BCom honors from Jai Narayan Vyas University, Jodhpur, Rajasthan. Worked as a legal trainee with the Mullah and Mullah, Carriage, Blunt and Corey, Mumbai. Then a leading law firm of country. He has also done LLB from the Government Law College, Mumbai, and enrolled as an advocate. He has practiced as an original side of Bombay High Court as a junior counsel. He has practiced in Rajasthan High Court at Jodhpur with Father late Sri D.S. Sishodia, a veteran leading senior advocate of Rajasthan with a large practice on all the subjects. He shifted practice to Delhi in the chamber of Sri Ashok H. Desai, formerly Attorney General of India, and appeared in the several cases, including as a several counsel for the central government to defend a Sardar Sarovar project. He is also independent practice, he is doing independent practice mainly at Supreme Court of India, represented Union of India, CBI, state government, statutory corporation and corporate houses before the Supreme Court of India and Honorable High Court and Tribunal Courts. He is designated as a senior advocate by the Supreme Court of India and practiced such in all the branches of the law. Participated and read the papers in the several national and international seminars on the all related subjects. So on this platform, I warm welcome to you, sir. Now I will tell Dr. Akhil Sayyed, sir, who is our Dean and Director at Parul Institute of Law, to warm welcome our both dignitaries. Dr. Akhil Sayyed, sir.
Thank you, Dr. Rajesh. Thank you for giving me an opportunity, and thank you for inviting such a luminary personalities here today on the virtual platform of Parul University. Honorable Justice Dr. Satish Chandra Saab and Pallav Sishodia Saab, it is our great pleasure on my personal behalf, on behalf of Parul Institute of Law and Faculty of Law, Parul University, I cordially welcome you on this virtual platform. And interestingly, my own PhD, I am the first PhD holder from the Gujarat National Law University, and my PhD is on public-private partnership in a legal education. And that is what I explored somewhere in between 2010 to 2015, and I have proposed one model also. So I'm really very happy that today I do have two luminaries who can review that model. Definitely, I'll share with both of you, respected sirs, so that I can get a feedback. This our Parul Institute of Law has been established in 2016 as one of the constituent college of Parul University, which itself was been established in 2015. So since then, we have, as I mentioned, my PhD topic was on a legal education, improvement of the legal education. So I made my all the experimentation with faculty of law at Parul University. We started with three integrated program, namely BLLB, BCom LLB, and BBA LLB. Thereafter, we started 3 years program, which I advocated in my thesis also, that NLUs also should start 3 years law program, because most of the elite colleges only provide 5 years program, and that is how 3 years program is somewhere is not been taken care properly. So with the same pedagogy which Madhav Menon Sahab has prescribed for 5 year program, we have implemented in 3 years program, and we are getting good results in 3 years LLB program also. In addition to this, we do offer LLM 1 year LLM program, and I am proud to say that we do offer LLM in 8 different specialization, and that is how we lead among all the private colleges, universities in the state of Gujarat. Now, new education policy has reduced the weightage, but we do also offer MPhil in law. Probably next year onward, it will not be continue. We do have research oriented our teaching, and that is how we have nearly 38 PhD scholar pursuing PhD in the subject of law. So it is a great pleasure that we are here gathered. So it is not only for the student and the other researcher, but it's personally for me also, that inputs from both of you would help me to make a better law institute. Thank you, sir. Thank you very much.
Now I will ask Dr. Satish Chandra sir to start the session on this topic, sir. Dr. Satish Chandra sir.
Please, audible?
Yes, sir.
Yes, sir.
My dear students, thank you. First of all, the life of the judge is very difficult. I'm telling you. In the courtroom, advocates never allowed to speak. They speak only they speak. When we return to the home, then wife will never allow to speak. And when we'll go to the room, TV will never allow to speak. But today I am very fortunate that Professor Rajesh Singh and the Dean Faculty of Law have invited me, and this opportunity has been provided to speak as much as I like. Thank you very much, sir. And especially to my co-speaker, that he has also permitted me to give the first chance. Today's topic is related to the legal education now and challenges. First of all, we will see the past history, the legal education. When Mughals were there and before Mughals, you will see there was no profession, no legal profession was there, not required at all. The king, who was the fountain of justice, or his representative, they invite the aggrieved party and offenders and solve the problem on the spot as far as possible. This was going on. But problem starts when the Britishers came in the year of 1600 or so. Then problem came because the judges were the English people, and sometimes the offenders or the accused were the black person. So how communicate his grievances or explanation, that was the main problem. So the legal profession was started. And when it was started, you see, first of all, we follow the British model. British model, there's a barristership in the British model systems after the legal educations, and barristership is not the examination, and no examination is required. If you will go to the Truth of the Gandhis, he has written himself, and he told you must be a junior to some senior barristers in the bar room, in the court, and then he will recommend your name, and you will have to arrange first dinner, and then after that the judiciary or the concerning judges, they will accept you, and later on another dinner will be given when that degree will be awarded or when the certificate of the barristership is awarded. So the people became the barrister without any examinations. That was the British systems. Similarly, here in India, the British judge or the judge, he appoint the vakil, and not barrister, but he appoint the vakil. And how he appoint the vakil? Uh, Again, the same procedure. The senior vakil will recommend the name to the British judge, and after one or two questions, he will award the certificate of the vakil. That was continuing. You remember, you will surprise that once a Gujarati fellow wants to become the vakil, so he approached the senior vakil who was his related. He told that I want to become the vakil in a Mufassal court. Mufassal court means district court. So he said, okay. Then he took him to the district judge, who was the British person, and told कि sir, he is an applicant for the to become the vakil. How much he don't knows the law? So then Gujarati said, sir, he does not know the English, so he can explain in Gujarati. I will explain to you further. Okay, all right. So he asked one or two questions. So Gujarati fellow was unable to answer. So then this middleman, the senior advocate, senior lawyer, he asked, the judge साहब is asking कि आपकी शादी में कितने बाराती आए थे और कौन कौन आए थे. Then he started explanation कि इतने घोड़े आए, इतने हाथी आए, इतने so much. When he was speaking, that judge said, okay, all right. He knows too much about the law. So then certificate was awarded of the wakalat. So that was going on. And later on, after this practice, this was continuing, there was another category, that is the Mukhtyar. Mukhtyar means power of attorney. The generally persons execute a power of attorney in the name of a person who was a clerk or who was working in the court. So he can argue and he can convey his grievances, he can convey his explanation to the judge in his in the language of the court. So that was continuing, this practice was continuing. But after the independence, there's a revolutionary change, especially in 1961, when the Advocates Act was passed. Bar Council of India was established, recognized, regulated. So this degree, formal degree, was made mandatory. 2 years course of the LLB was there at that time, and that was the additional course. You can do MA or another degree simultaneously. You can do LLB for 2 years course, and that was totally additional. And person was doing, or generally people were doing additionally by hobby or by these things. Hardly 10 or 20% persons go to the practice in the court. Similar practice, similar ratio is continuing even today. So when he passed the LLB and then he became this vakil and all these things, so that was there. So Bar Council has made it mandatory that there must be an advocate, and now this will be 2 years course. Later on, it was converted to 3 years course. Immediately that will be, and later on, no simultaneous degree, no other degree. Exclusively law for 3 years study is required for LLB degree. So this was made mandatory by the Bar Council of India, and but it was the part time. Even then, part time in the evening, not in the daytime. So maximum during even our period when we were studying, it was in the evening classes when it was conducted as a part time study. And the advocates, senior advocates from the bar, they came and they give the lecture. Part-time lecturer, they were the part-time lecturer, full-time sometimes, and they were the holding the deans and all these things. Then UGC and Bar Council of India, they said no, nothing is there. Person must be the whole-time teacher, and they may be the guest speaker only. So now regular faculty is required in the college who is providing the legal education LLB course especially. So that was continuing. And region in the old time, as I said, the presumption was this, maxim was there, everybody knows the law, and there was no legal education required. But when you want to convey to the judge the grievances of another person, naturally you need a professional degree, and your registration is must for this one. Bar Council of India nowadays is only the regulating authority of this profession, and they conduct time to time the inspection of the college. Perhaps after every 3 years or 2 years, they conduct the inspections. I am associated in that inspection committee, legal education committee, as a chairman, And I have seen so many colleges or inspected so many colleges and universities. And first of all, we will have to see the infrastructure. What is available there? Infrastructure. I went to a particular college. There was so much dust on the benches, just like a class 5 or class 6 benches there. So there was no infrastructure, but they were providing the legal education. So then objection was raised, obviously. So now the Bar Council of India, in its regulations and rules, have laid down the size of the room, furniture, and the strength, how many students can study. They put the cap 60 students in particular section, and you have only 2 sections, 3 sections, whatever may be, for 3 years or 5 years. That is there, and all informations is available in that booklet provided by the Bar Council of India, and we also see in infrastructure, wash or toilets are there, common room for the ladies, girls are there, seminar rooms are there, conference, auditorium, and moot court, especially the moot court also there. The infrastructure for moot court is there, and how much library they have in the how many books they have in the library, whether there is an internet or journals online is available, or hard copies are also available or not. So that is the part of the inspection team, so they will have to see. And another aspect, we see the medium, what medium they are using, Hindi, English, or local language. Nowadays emphasis of the government is to provide the education in the local language, regional language. You have seen the prime minister recently said that even medical educations, engineering education will be available in the regional languages. So similar position is in the legal field, that there must be a legal education in the local languages or regional languages. But problem is this, that we are following the British system of law, British education. During our time, your professor and dean might be aware that they read the British legal history, Roman law. All these subjects were there at that time, not nowadays. So we are following the British system of law, and the basic law, even IPC, Evidence Act 1861, 1908, all these things are still continuing. So the local language books or literature in the local language is very not a very good quality, but a cheap quality, you can say. And they are the just question and answer series, for in the form of question answer series, all these things. So there is a lot of scope for the improvement of that language. You may provide the education in regional language, but provide the research, provide the books of standard. And that one, for this purpose, in the law ministry, where I am also the chairman of this funds distributions, we are providing the funds for writing the books, quality books in the regional language. In the so that is there. So professors, teachers, they can write the books in the regional language and can send the same to the law ministry with the Sahitya Prakashans and the legislative department for grant, for publication of the grant, and they provide this one. So there is a lot of scope for improvement of the books, and you can say the material available to be available to the students. Bar Council of India recently has put the cap, and moratorium has been put. Since 2018, there is no permission for the new law college. Otherwise, there was so many law colleges were started even in the remote area where teachers were not available, but they put the moratorium that no new law college will be started since 2018, and since then, uh, only old colleges are continuing. At present, we have 1,500 colleges or schools in the universities. Those are providing the legal educations. 23 national universities are there, but they are not the national university, they are the state university. Name is, of course, nomenclature is, of course, National Law College or National Law Schools or National Law College. This concept was started by Professor Madhav Menon, who started the 5 year course first time in Bangalore. So since then, this National Law University concept has emerged, and every state has at least one National Law University, and that is going on. Now, problem what comes, the problem is main problem in the legal education system is the faculty. I have visited Chhattisgarh in remote areas, also the law colleges. There are no teacher, only part-time teacher, or they have shown the name of one teacher in three colleges. How it is possible? So that is there. And private universities, they put the some renounced professor as a dean or as a some head or something like that, working executive or something like that, whatever designation they want to they give, and they pay such amount. That's all. And he never visited the faculty and never this things, only for namesake they pay some this amount. Teachers are available who have not qualified the net, who have not qualified the PhD degree, and they have not earned. I met one person's one professor in some remote area also. He was getting only 15,000 rupees. I said, why you are not going outside and get the regular pay scale which is prescribed by the UGC? He said, no, no, sir, this amount is sufficient. I am at my home and I just came here for 2 hours. That's all. For 2 hours, and then it is okay. So he was happy and not qualified this one. So such type of teachers, how they can provide the quality education? This is a question, big question. So my submission is this, that there must be the regular postings, all posts should be filled up, no vacancy should be there, and teacher must be qualified teachers. Not necessarily they should be local teacher, they may be outsiders. You may borrow and provide the best facilities to them teachers, and that they can also produce the good students for future. In Vilaspur, I went to a university. Uh, there I found that there was no dean, regular dean. The veterinary department's head was having the additional charge of the law faculty to perform as a dean. So such type of scenario even today is not good. Nowadays, we are having this 5 years course, 3 years course, all these things, but we want the quality educations, and it is possible only when we will have the regular teaching staff, or you can say the qualified regular teaching staffs there. 1.5 lakhs students are clearing this LLB examination every year in India. Is it not required? I think so. Like CA Institute, Chartered Accountant Institutes, there must be some cap that we need only this year 50,000 enroll LLB graduates like this. Because in legal profession, nobody is going to retire. As old he become, he will be more famous, and he can earn more fee because he is having so much experience. So there's no retirement age, no upliftment, unless God will call them. That's a different issue. So there must be some cap. We don't require 1,50,000 per year. It must be regularized. I can't say how much, but it should be regularized according to this one. In this 1.5 lakhs students, only 30% goes to the profession. Only 30%. Rest goes either to the service, or they have the LLB degree as a piece of decoration, or just against their name, or after retirement they will do the practice, something like that. But in active practice, only 30% students are there. Even 30% students are creating the crowd, and crowd means no quality advocates. You may find the crowd in the courtroom in Allahabad. 11,000 advocates are there, but hardly 200 or 300 are the advocates who are regularly appearing. Rests are coming and doing the job, seeking the adjournment or minor duties they are performing. So that is also not required from this one. If you want to go to the practice, go seriously. You want to do practice, you do practice seriously, not casually. If a girl is not getting a husband, what she is doing, she is learning the knitting and embroidery. So that is not a time pass. That must be a regularized, and seriously they should do it. In the legal profession, another aspect I will say, when they will go there, and I will request to your dean that ethics paper, there must be an ethics paper in your syllabus, professional ethics. So in that one certainty, some certain changes are required. For example, you should tell the students that strike is an abuse. Strike by advocate is an abuse. So that should not be there. The purpose is this, that pendency should be finished. Being as an advocate, and when you will become the judge, you will also try to finish the pendency and never contribute for increasing the pendency. That is the first aspect which you can learn from the paper of the ethics, all these things. In because this is a strike or by pendency, a lot of problem are there. And Ramanna, the Chief Justice, and Ramanna said that 16 years will be taken to clear the backlog. Now we have about 4 crore, 3 crore 80 lakhs pendency, and one third is in the lower court. One third is in the lower court. And in Allahabad High Court, which is the largest high court of the world, pendency is more than 10 lakhs. Judges number is 160. Even then, pendency is not reducing, but that is increasing day by day because fresh filing is too much. For this one, the Supreme Court recently has taken the view that the services of the retired judges may be taken on ad hoc basis, and there is already a provision in the Constitution for the ad hoc judges, and they can reduce only the old pendency. 5 years old cases can be given to them. As I told you, the people are waiting in the criminal cases from last 25 years, 30 years, and contribution partly and actively goes to the advocate because he lost the interest in the old case. He is more interested in the fresh case because fresh case provides the immediate money. Old case money has already gone, consumed. So his interest is less. And one father was the renowned advocate. His son was also an advocate. So father was absent for marriage or some other reasons. When he returned, the young lawyer told his father, "Papa, I have finished the case of the Rai Sahab in your absence." And he was expecting some appreciations, but father beated him very badly. Bloody fool, the fee of your education came from that case. The marriage of your sister was performed from that case, and you have finished it. So that was the approach. But now approach is different. As an advocate, as a young lawyer, as a bright student, I expect from you that you should believe in the corporate life, more turnover. If you will provide the best service to the client, he will send 2 clients more. If you will squeeze only one case, that will continue. He is helpless because the advocate is the god for his case. So that will continue, but he will never send any new client to you because he knows how much squeezing you are doing and how much dependency you are keeping, and you are not interested for the disposal of the case. So my submission to the young students is this: they should think that pendency or arrear is an abuse, and you should not make any contribution as an advocate or as a judge. When you will become the judge, also don't make the contribution for increasing the pendency. And this one, no strike, nothing. Now we have the National Judicial Data Grid. National Judicial Data Grid. They are providing the disposal of each judge. You can see nowadays any judgment of any judge on the website. You download the Allahabad High Court website, you can find the judgments, how many cases were disposed of, like this. So now everything is online. So as a judge, when you will be judged, don't make this that your disposal is very poor. And I expect in future that at the time of elevation, some credit will be given to the judges who have given the best performance. And also because there will be more vacancies in near future. At present, we have per 20 lakh population, one judge only 20 lakh populations. So how much judges are required in India? So number of judges will have to increase for reducing the pendency. And I told you that when you will be judges or advocates, you should try that your all cases of such type of cases, similar cases, should be bunched. For example, in income tax, there are different assessment years. So what we will do, we club all the cases of that SSC because common point is involved in every year, and all cases can be disposed of by one stock, or you can say by one judgment. So that things can be there. Another aspect of the legal education of nowadays is this: after having the certificate from the bar council of advocate, you are entitled to do practice throughout India, anywhere. When you start the practice, you have the right to start in any field. But nowadays, in medical science, in legal science also, the time has come for the super specialty, specializations. If you are the advocate of service matter, you are the advocate of service matters. If you are the advocate of the criminal matter, naturally criminal matter, taxation. So specialization is required for this one. But what they do, they catch the youngsters, catch the, perhaps there is a financial constraints also. He catch all the cases, whether it is from Patiala House in Delhi or in Dwarka in Delhi or in CAT, Central Administrative Tribunal Delhi, and आपके this Rodra also. There must be some various courts. So he catch all the cases and run from pillar to post and this one. Somewhere he asked the proxy, please seek the adjournment. I will not attend, and that amounts to a delay, of course, when adjournment is granted. So calendar is full, so his number will come after 3 months, 4 months. So naturally this increase the pendency. So when you are available whole the time, suppose you are the advocate for the service matter or criminal matter in a particular court, so you must be available around the you must be available whole working days in that court, and your knowledge in that subject or that court will increase, certainly increase. And when you are available there, you will not seek the adjournment, and your case will be disposed of very fast. And client will also come. He is exclusively available here. I asked one advocate, Ramchandani, he is no more. He argued my case in CAT. So I asked, please argue in High Court. He said, no, I cannot go outside the premises of the CAT, only CAT. So this type of advocates are there. They are confined to the court, particular court, and they will do it. Basic law, everybody knows. Criminal law, everybody knows. IPC, CRPC, and civil code. And this aspect is available already in the USA. I visited the USA. They asked, Bar Council asked me to deliver the speech on the areas. When I talked about the strike, they surprised. What is strike by advocates? It is not possible like this. And later on, there were so many questions and hours. Then I searched what was the reason. Because after getting the degree from the Bar Council, registration from the Bar Council, he will apply to the particular court, for example, High Court or District Court, to do the practice in that court. The head of the court will grant him a permission and certificate, valid for 3 years or 2 years, whatever may be. And then he is allowed to do practice in that court only. The exception is only the senior advocates. They can do practice anywhere in India, even without wakalat nama. They can argue the case. But for the youngsters, registration, or you can say the enrollment in a particular court is required. And maximum one advocate can seek the enrollment from 4 courts. 4 courts. So his availability is always available in 4 courts. So now there is a corporate life is there, that in the company now in India also, Singhania and company, so many companies are there. They are forming or firms and associates. So they assemble in the evening. They distribute the work to the each advocate who is representing a particular court or particular subject, and he is arguing there. So there is no question of the seeking the adjournment. So this is the time has come when corporate practice is required. Nowadays, scope of the law has increased a lot, because after the liberations in 1990s and onwards, you will find the multinational companies have come to India, and there is a need for the investment, merger, acquisitions, pricings, taxations, agreements, international agreements. So corporate life is also there, and big firms, what they are doing, Singhania and Company and Motilal and Sons, all these big firms, they hire the bright students from the universities, 5 years courses or like this, and they provide the chamber, glass chamber, AC facility, all facilities are there, 50,000 in the beginning, and the boy is very happy or girl is very happy, student is very happy in starting his getting, and he is working like a machine. And what this organizations, that company is doing, they hire the advocates who can argue in the court. So you are preparing the case with the help of the client, and you are giving the brief to the one responsible officer of that company, and that company is giving the brief to the arguing case. So you will never see the face of the court, and that advocate who is arguing the court, he will never see the file how it was prepared. So this is the whole game nowadays they are doing. If you want to do practice yourself, because he will remain confined to that company forever life, he will never go to the court, and the court person will never come to this one. So that profession, legal profession, will flourish. I met Shanti Bhushanji, very senior advocate, in a particular case. He prepared the notes in his own writing, own handwriting. After the argument, conference, he put the so many questions, reading charges he has taken, and he put so many questions, and he understood the case very well. Then he prepared the notes, and on the date of conference, and then he put the notes in the file. Whenever case will come, no matter, he will just refresh what he has written in his own handwriting. He will refresh. Nobody can understand his handwriting or his code words what he is using. So he was not bothered to see the file at that time. What nowadays advocates are doing, when when the case came, old case came, then he searched the file. Where is the file? And then he prepared and he will read it. And he lost the interest being an old case. But Shanti Bhushanji, I will appreciate that he has prepared the notes in his handwriting. P.P. Rao, now he is no more. He also do the same things. He prepared the notes in his own writing. And whenever case came, they just refresh the memory and start the arguments generally. So this practice is there. So those advocates, those students who are interested to go to the bar to do practice, my advice is this: whenever they will get the case, they should think tomorrow is the hearing. Tomorrow is the hearing, and so he should prepare all the case and prepare the notes, everything, and confine the file. Matter may come after some time, no matter, no problem, and they will do it. And confined to the particular course, just like Amriga, 2 or 3 courses, and have the specializations, then your future is bright. Your elevation in that line will be there. I was the man of taxation. I was elevated because they required the taxman. So there is no bar that if you are doing practice in the tax, you are doing practice in civil, you are practicing family law, you cannot be elevated. You can be elevated anywhere because your judgments will be reported, and you have the specializations. So these are the points what I will suggest for the new generation, that they should adopt in their profession. Parole University, as I heard, I have not seen so far, is a very good university. It has a good infrastructure. Law faculty has a good library, as I came to know from my colleague who has inspected the bar from behalf of the bar councils. So I think when everything is there, good teacher, good faculty is there, so students will come with the bright future. And I have all the best for them, and my good wishes are with them. Thank you very much.
Sir, it was
question answer I will be there.
Yes, sir. Sir, it was a very fantastic session. You have elaborated in a very systematic way with all the aspect regarding the inspection, regarding the British system, the starting history. You have elaborated in a so systematic way, sir. Now, sir, it is a chance to be given to senior designated advocate, Mr. Pallav Sisodia Saab, who has lots of experience, and he is a very renowned advocate at the Supreme Court of India. So now the session is handed over to you, sir. Pallav Sisodia, sir.
Thank you, Rajesh. Dr. Rajesh Singh, Dr. Akhil Saeed, Justice Satish Chandra. I am actually very beholden to be sharing a panel with Justice Satish Chandra, whose awe-inspiring background, not only as a lawyer and a judge, but as an academician, and also being an advisor to governments for various constitutional matters, the governments outside India. I really feel privileged, and I'm thankful to you to permit me to share this dais with such a distinguished speaker. In fact, nothing much is left for me to say, but still I would share some thoughts. It is somehow, I do get a lot of work from Allahabad. I have a lot of lawyer friends in Allahabad. And somehow I missed interacting with Dr. Satish Chandra in any capacity. But I think Allahabad High Court is famous for the judges not knowing each other. So if the outsider lawyers may not know you, it is not so much our fault.
That is true. When we sometimes we meet at the railway station, New Delhi station, in the compartment in the first class.
Yes, sir. So now, but I have two very comforting links to talk about. One is your stints in Rajasthan, because I am also from Rajasthan. And your recently retired Chief Justice Govind Mathur. We have sort of grown up together in the bar, and he's a very close dear friend. In fact, yesterday I spoke to him about the article I have written in Indian Express for the universal vaccination in this current pandemic. Dr. Rajesh Singh, you may share that article with
Yes,
Dr. Satish Chandra.
Yes, sir.
Now, and I'm very thankful that you brought this issue about 1,500 colleges producing 1.5 lakh law graduates, of which only 30% go to the profession. Now, one is the litigation branch, as we all traditionally know it, and the other is the corporate branch. And it used to be a joke some time back that how, as a corporate lawyer, you would learn law when the judge, you don't hear the firing from the judge, when you don't face the court. But I must say that, the things have changed a lot. And the corporate lawyers are doing a lot of critical work of the field for which people like us may feel totally illiterate. So as the society grows, as the economy grows, the complexities are growing, and there is a lot of critical work done by corporate lawyers also. But 70% of them, perhaps some of them go to the businesses, they are perhaps having the startups. Something like Uber is in India is by a law graduate. So that is another dimension. But I would talk a little bit about one of the survival kits, because when you are part of such a growing number in the profession, and Dr. Chandra has really put the statistics in a very alarming way. So there has to be some survival kit, because the first casualty is the professional ethics. And because it becomes a race for survival. It becomes a kind of a challenge for survival. And therefore, I would talk of one tool in the kit which the law graduates must consider developing for themselves. Now, there are, issues, if I can flag, about what should be the curriculum. Should it be very comprehensive? Should it be narrow, more confined to law? There are issues about library and the infrastructure for the colleges. There are issues about law teachers, their availability. And Dr. Chandra has pointed out that how sometimes the whole system is misused by just taking up the teaching job for the namesake and doing a lot of other things. Then there are issues about internship, availability of internship. Should there be a common grade? Because it becomes sometimes, for the students who are not so well connected, a big challenge to have a good kind of internship. Then there's this debate about 5-year course versus 3-year course. Of course, now the balance has now tilted for the 5-year course, which is much better, as I would discuss with you, than what we had as 3-year course as a refuse from everywhere else. Everybody would go to the law and do the 3-year course. So it is very different. It is much better. There are issues about also continuous training for lawyers, because even for a person like me today, if there is a ticklish issue on, say, IT law, information technology law, I may be at sea. I may not be able to understand the full thing. So if I am not educated again or if I'm not exposed to the new subjects which are emerging, because there are a lot of old subjects which are dying also at the same time, like MRTP or the monopolic restrictive trade practice. Everything is now out of bound. And then there are issues about the autonomy of the colleges, bar council versus the universities, etc. Now, I would not touch on that, but I would talk of in a different way, as I said, about the survival kit for the students, and I would talk of what is called a traditional concept of swadhyay. Now, before I come to that swadhyay, I must say that, for those of us who were educated in 70s and 80s in Middle India, and I'm using the term Middle India, the current state of education in general and legal education in particular is a story of half glass empty and half glass full, but with lots of different contents than what we had in our time. And that is what I want to talk about, because first, let me talk, what is Middle India? And that is what, I would identify with the students of the Parul University. I think Vadodara is the town. So the Middle India is the India which is of the not so well-off small towns and the semi-rural areas, where schooling and college studies are in vernacular, not in English, and at best in a very faulty English. Now, for this Middle India, the proficiency to communicate in any language remains very poor. So you have this problem today that we are not able to communicate in vernacular language for the formal matters. You can talk informally, you can talk colloquially, but you can't talk for the formal things even in your own language. And then you are poor in English, so it becomes a very big challenge to assimilate the subject, to grasp the subject, to express it properly. Now, this is because vernacular languages have their own limitation, and the languages also have limitation. Now, for a technical term, how much you can use the vernacular language. And the faulty English creates its own limitation, because you are able to think half and express half, or half of that half, and it becomes a very big problem. We talk of English as a universal language of higher learning, because that's the only thing, because even in Europe today, the European languages are now giving space to English. So you would not find in France or Portugal so many English, so many Portuguese or French speaking people as many you would find the English speaking people, because everybody has to learn, and it has become now a much popular language for business. So from continent to continent, from US to Europe to America, wherever you go, Africa, English is a must for any formal communication. And this is also India, the Middle India, which has a lot of success stories, because you would find that some of your friends, some of your relatives have done exceedingly well against all odds. And it raises the aspiration level of everybody very high, and nothing wrong in that. It should be so. But therefore, we have to understand the challenges we are facing. Now, going back to the 70s and 80s, the graduation had lost any value except as a paper degree, and it has not improved much. So if you are simple BA, you are just considered to be a matriculate or even literate, nothing more. Or even MA, you are just a literate and nothing more. Now, law was the last refuge for the failures everywhere else. The classes were few. I was in government law college, which produced Palkiwala onwards to best of the people, but that is only claiming a kind of lineage, nothing much. But we had only 3 classes in the morning, 7 to 10, and the whole day you were free. So the classes were few. textbooks were rarely touched. So we had a book on constitution by Das Basu. But most of us read from a Japwala series. I don't know which series is. I don't know which series is popular in Vadodara, but these are the series we all grew up with. Now, so we mugged our way through just to pass the exam, and without understanding much of what we mugged, and we just regurgitated everything in the in the exam paper. Now, thus we got our degree of LLB, which wise people only called it only a license to study law. And even today, with your good, comprehensive 5-year curriculum and a 5-year course where you study the humanities and the law together, it is still a license to study law. And you must understand this. And when legal knowledge, the actual legal knowledge come to us much afterwards when we bumbled our way through in the profession. Now, there is a 5-year course. So, this 5-year course is much better than what we had. And that is why I say half glass full, because it is much better than what we had. Now, the level of graduation in the law taught, the moot courts, the moot court competition, I remember the first moot court competition, in my overconfident manner, I went and fired the opponent on his case, etc. without any more. And then I realized that how
मैं इधर से ट्राई कर रहा हूँ।
मैं वहीं बैठी हुई हूँ अंकल, हॉस्पिटल में बैठी हुई।
हाँ, तो बेटे उससे डॉक्टर से बात करो, कोशिश करो थोड़ा सा।
मैं कर रही हूँ, मैंने 2-3 लोगों को बोला है अंकल।
हाँ, चलो मैं करता हूँ।
Now, so you have better moot courts, you have much better internships, you have much better general exposure, because the level of general education is better, the knowledge of English is much better. For people like us who shifted from vernacular to English, the whole process of translating something which is said in English in your language, then understanding it, and then when you want to speak, you think in vernacular and speak in English. So it was a very difficult, arduous journey, which a lot of you are not having that much. Now, for serious research, I think Dr. Chandra, if you can mute your mic, it will be helpful. So,
चंद्रा सर, आपका माइक ऑन है, माइक को ऑफ कर दीजिए।
Now,
hello.
Yeah. Now, so therefore, for serious research, one does not need to come to library, as textbooks, law journals, study material, both Indian and foreign, are available now on your laptop. We had to go to a big library if at all we were ever serious about anything. Now, yet there may be issues about access to infrastructure, assimilation, as we talk. So with this, you have this half glass full. Now, in all this, after all this, with this half glass full, what remains true is that even now, a degree of LLB is only a license to study law. It is a much better license than what we had, but it is still only a license to study law. And it shall remain so whether you aspire for corporate practice, because what the corporate lawyers do, and sometimes they are overburdened because they are working on a different schedule. You have an American client, you are working on his schedule instead of his working on your schedule. And there are so many other things. Sometimes they employ 2 people for the work of 5 or whatever. Now that's a different dynamic. And here comes the challenge, that how to become more proficient and make your survival better and make your place better in the world, in the challenges ahead. And this is for these students more as I'm sharing some thoughts for them to reflect, because I am not a person who can preach because I have not attained much in life. So to preach. Now, the first thing they must reflect is how much concentration they are giving to the studies they have. Now, the concentration as against not a boyfriend, girlfriend, but as against the social media. This is the biggest distraction of our time, that you go to a place, you meet a person, and you're busy with your social media. You're not present in that moment, but you are elsewhere. And when you go elsewhere, you come back to that meeting where you are busy with the social media. So one thing the students must reflect is about concentration without digression of the social media when you are studying law. That's one point for reflection, how much you can do that, how much you can detoxify yourself from the social media. Second is the challenge of a sustained learning. Now, what you learn from books, what you learn from a healthy debate, what you learn from a very keenly contested moot court, you cannot learn from what is now much more prevalent, the university of university, the WhatsApp university. You communicate very fast. You are disseminating knowledge very fast through the WhatsApp. Quick wisdom on every subject. Now, please think of refraining or keeping yourself limited or keeping yourself away from that. So that is point number 2. The third point for consideration is reading and understanding. Now, I remember there was a lawyer in Jodhpur in my young days. So he came to court and he wanted the matter to be adjourned. And he was known to be a very tactful person. So he tells the court that, Lordships, I have not read the brief. No, I have not seen the brief. Please give me time. So the judge was very keen to go on with the matter. So he said, okay, you look at the matter and come tomorrow. So he comes to the court tomorrow because next day also he wanted to have the matter adjourned. So he says, Lordships, I have seen the brief, but I have not read the brief. And therefore I want the time. So next day he again goes and then he says, Your Lordships, I have seen the brief, I have read the brief, but I have still to understand the brief to make a cogent argument. The judge got very exasperated and he said, okay, now come after 2 weeks and you please understand it properly. And now there is a difference. I remember one of the briefings with Mr. Fali Nariman, who is our legend in the profession. He said, you have seen the brief, you have read the brief, but have you understood it? Have you understood it? And he would encourage a dialogue for a critical understanding. And that is my next point, that we must be able to analyze the problem as a legal problem in a critical way. There are always a point against you. There is always a point for you. Now, as a lawyer, your duty is to enhance your point of view, of course, remaining truthful to the court. But there are so many unexplored facets of law. There are so many unexplored facts of the matter. So a critical analysis is something you must develop. So even when you study, when you read a topic, suppose you are given to read Article 14. Now it's very simple. Nobody shall be deprived equality before law. But it has so many dimensions, so many ways to look at it, so many perspectives to look at it. And therefore, it is important to develop critical understanding. And nobody will do that for you unless you do it for yourself. And then developing expression. Now, expression is not only good language, but expression of ability to understand and look at a problem as a legal problem. Now, suppose you have a matrimonial dispute. Now, every husband will say, wife to pagal hai. But this is not the legal way of looking at it, because in law, you have to talk of unsoundness of a mind, which is a very different concept than just saying, ye to pagal hai. Now, therefore, your expression and thinking it is linked with that. Thinking of the problem or the issue in a legal sense and giving an expression in a legal sense. Now, it is very easy to say that there is a pandemic, but what can be the legal dimension? What are the issues, say, about the patents for the pharmaceutical companies who are manufacturing vaccinations? Can it be taken over by government? Can there be more production? So now that is the legal way of looking at the same thing, instead of looking at it as a common sense or a common man. Because you are going to be a lawyer and you must think of looking at the problem, thinking of the problems in the legal way. And then also, as a lawyer or as a budding lawyer or as a law student, you must increase your general level of awareness, because law is very much part of the society you are living in. It is not divorced from the society. So if you have a better awareness, whether it is political, whether it is historical, whether it is, and for that, the only way out is the general reading. The general reading, not only of the law books you read, but the various subjects. You know, somebody may like history more, somebody may like psychology more, somebody may like the human relations more. Now, if you are a good criminal lawyer, and if you don't understand the human behavior properly, you cannot be a good cross-examiner. You cannot be a good lawyer to present a case. So now these are the few things: concentration without diversion of social media, sustained learning away from the WhatsApp university, reading and understanding the issues, the brief, the legal problems, critical analysis, thinking, expression, general awareness, and general reading. Now, these are few of the things I would like that law students concentrate, because you are in a world where you would be tackling with the numbers, and it would always be challenge, and it was always a challenge even in the earlier times, that out of 100, only 5 made some name in the bar. It may be today 500 and 20 making the name. But the challenges remain, and the challenges can only be, and this is not only a matter of meeting the challenge, but at the end of the day, you have to evolve as a human being, you have to evolve as a lawyer, and you have to evolve as a citizen, so that you are able to give your contribution back to the society. And with this appeal to reflection, I'm not preaching anything. Please control your WhatsApp. That is preaching. But when I say that, please reflect. What are the consequences of too much of social media? What are the consequences of too much of WhatsApp university? You reflect on that. With that, I would now conclude my interaction. It is wonderful to talk. It is very energy giving to be among the young people, though I am physically not there. But I hope that sometime I meet and be among you. Thank you.
Sir, it was a very nice session by both of you, sir. Sir, we have certain questions from our students. First question to Dr. Satish Chandra, sir. Dr. Satish Chandra, sir. Sir, please put your speaker on. Yes, sir. Sir, first question from one of the student of LLM. So he was asking that, sir, in the trial courts, the matters are taking a long time, in the trial court, because, if there are lots of evidences are there. So in the examination in chief and cross examination it took say lots of time. So can it be possible that this the duration of trial can be reduced because of your lots of experience, lordship? Can you just elaborate on this?
Mr. Shishodia perhaps may not agree with me. The main role in this one, not only the court, they are overburdened, but this is the advocate who, after getting the fee, he hand over the file to the clerk and fee to his wife, and is free to his friends in the evening. So that is one aspect. So I told you in the beginning, if when you accept the brief, you prepare your notes and prepare your case as it is coming tomorrow. May come sometime later, but that is not so. In trial court, main reason is the overburden of the advocate and the courts. Adjournment is a common phenomena. Advocate is not available. He is moving in another court or in another city. So how he can be alibi? How he can be present at two places at the same time? So that is not there. It can be reduced if you will make a contribution not to seek the adjournment.
Yes, sir. Very good answer, sir. And it was really a pleasant answer. Sir, one question to Pallav, sir. Pallav Sisodia, sir. Sir, as in the Supreme Court and in the Honorable High Court, sir, there are various junior advocates who are joining for in the initial stage, but the senior advocate do not give certain amount in the nominal amounts also. So in this connection, sir, Supreme Court Bar Association has taken certain steps by providing certain 3,000 or 5,000 rupees. So can it be increased, sir, for the because ultimately at the end of the day, every junior also needs certain amount so that they can expense his own expenditure. Hello, sir.
You see, I would like to remind for this question, as was also a part of the last question, there's a principle in Jainism called Anekantvad. So now the same problem has a different perspectives. So the legal delays has a perspective of a judge, is a different perspective of a very busy lawyer, and a different perspective of a lawyer who is ignorant of what has to be done in the matter. Now, likewise, this problem about the junior-senior relationship. I grew up in Bombay Bar, and I don't know how it is not mentioned in my biodata. I was junior with Mr. Ghulam Vanvati, who also became Attorney General, and my other senior in Delhi, Mr. Ashok Desai, also became Attorney General. Now, in Bombay, there was no tradition of paying any junior at all. And this is how the profession grew. Because, in England, the people, the nobles, the people from the rich family only joined the profession and they roughed out. Now, one of the problems is that when you are a fresh law graduate, what is your economic value? What is the services you can give? And then still, they say that no, even if you're learning, you must be paid something. Now, it also depends from chamber to chamber. But when I shifted to Delhi, there is a tradition of paying to the juniors. But you would be surprised that what is paid even in a liberal chamber, in a litigation chamber, is only 1/4 or even less than what a law graduate gets in a corporate law firm. Now, over the period, the litigation lawyers earn much more. Not so much, the corporate lawyers are not able to earn so much. So this is a very complex problem of the various economic considerations which prevail. But of course, a good liberal senior who is doing well normally pays well, at least what is good for survival. And I don't think in Delhi anybody pays 3,000, 5,000, because it is normally 25 plus, which is the normally paid. But this is again, different from person to person. And that is why when you are with a license of law, there is much more ahead and a struggle ahead. And this is the part of the growing in the profession.
Thank you, sir. Very well said, sir. Sir, Akhil sir, are you there? Akhil sir. Hello.
Yes, Dr. Rajesh. As I
Sir, you would like
anticipated,
to ask any question, sir?
it was really fantastic, and I also learned so many things. I have prepared my notes also. It was because of poor connection. I had to turn off my camera again and again. Learned advocate Pallav sir, actually, as I mentioned in the beginning, we are doing all this experimentation at our institute also, and that is what you said repeatedly, that 5 years course is better, but we are making 3 years course also better. We are
It
giving
should
the
be.
same pedagogy, because it is what I understand as a teacher, it is a pedagogy. How do we teach that subject? So let
Absolutely.
me tell you that whatever 5 credit papers we do have, uh, we give 6 hours for that. So 5 hours they learn in the classroom, and the 6 hour they go to the courtroom, moot court. And in a moot court, whatever, even if it is a law of contract, the students are being asked not to refer Agra Law Series or Jhabwala, the actual case, the judgment. If it is Mohiri Bibi versus Union of India, then students are being asked to read the complete Mohiri Bibi and come prepared next week. So that and we do have associate professor like Dr. Rajesh Singh. We do have adequate faculty, rather more than what is been expected by the Bar Council of India, because that is what our management says, that forget about the criteria of the councils. We need to provide better to the students, and that is what we are inculcating. So it is really good, and I invite both of you physically, once all this pandemic gets normal, please do come at our institute, and I'm sure you would like our all this experimentation, and we would be able to show you our success also in all this area. So
I'm very glad. I'm very glad, Akhil, that you mentioned that you're taking 3-year law course also very seriously, because see, ultimately 3-year law course you do after 3 year of graduation. So it is actually 6 years instead of 5 years,
yes,
because 5 years you are doing your graduation also. But I'm very glad that you are moving to the non-conventional teaching methods also. The whole thought of provoking thinking and critical analysis is something I would always urge to the law teachers and the students on their own to do that. Thank you. Thank you.
thank you, sir. Thank you very much.
Thank you.
So
Thank you
from
all
this,
very much.
sir, we are closing
It's
this
a pleasure.
session, and we are thankful to all both the. Yes, sir. Yes, sir. So we are thankful to Dr. Satish Chandra, sir, and Pallav Sishodia, sir, for giving his precious time to our university. Thanks a lot, sir, for this webinar, sir. Thanks a lot. And we are also thankful to Jitin Kubani, sir, who has given a live coverage on this. So thanks a lot, sir. Thanks a lot.
Thank you,
Thanks a
We
lot.
are
Chandra.
closing this
Thank you.
session.
चलिए शिशोरिया जी मिलते हैं. Thank you.
Thank you, sir. Jitin, sir, now we are closing.